The Litigating Rights conversation is a series we have every term in which we explore issues that arise for litigators in seeking to promote and protect human rights in a range of different places around the world and in a range of different fields of law. And I can't think of two people I would more like to hear on the question of litigating rights than Mark Heywood and Maya Foa. Mark Heywood commenced sort of litigation work, I think, with the AIDS Law Project in Johannesburg in 1994, just at the commencement of South Africa's new democratic order. And he then became one of the founders of the AIDS Law Project, which has played a significant role in seeking to protect the rights of people living with HIV-AIDS. And then in 2010 was a founder member and director of Section 27, which is an NGO in South Africa named after the provision in our constitution, which protects economic and social rights, in particular right of access to water, to food, and to healthcare. And so those are the things he's going to be talking to us about today. Maya is based here in the UK, and she is the director of the legal charity Reprieve UK. There may be people here in the audience. Yes, I see at least one, Rahul, who has been one of the students from Oxford who served on one of the Bonavero summer fellowships at Reprieve UK. She leads a team of lawyers seeking to protect people from grave human rights abuses and works particularly in the field of the death penalty, rendition, and torture. One of the reasons she's famous is for her development of a strategy around attacking the supply of drugs used for the implementation of the death penalty in the United States. And she really was a very successful campaign for a number of years. So both Maya and Mark have been involved in thinking about how to protect and promote human rights, not only through the use of law, but through a range of other mechanisms as well. And I think that's going to be the real focus of this evening's conversation. We're going to start off with each of them speaking for 15 to 20 minutes about their own careers, which will give us all a deeper understanding of who they are and what they've done. And then I'm going to ask them a few questions, engage in conversation with them, and then we'll open it up to the floor. So Mark, if I could ask you to kick off. Thank you.
Good evening, everybody, and thank you very much, Kate and Maya, for the introduction. What Kate didn't say, I can describe myself as a litigator, but I'm not a lawyer. I think I probably fall under what you describe here as legal practitioners. I came to Oxford 36 years ago and studied English language and literature. And when people ask me, how did I end up in law, I say, well, English literature teaches you how to read, and it also teaches you how to be a humanitarian. But it took the tutelage of a lawyer who was in the underground in South Africa, a chap called Rob Peterson, in an organization called the Marxist Workers' Tendency of the ANC, to teach me how to write, because I think from law you get a logic and an ability to write with a precision and with a clarity. So it's a little bit intimidating to speak here as a non-lawyer before an audience of presumably mostly lawyers, but I relish the opportunity to have a discussion about litigating rights at a time when I think the very idea of rights is under attack, both from some of our colleagues on the left who question whether it is radical enough and efficacious enough in bringing about deep change, and obviously under attack from the right, who question the very notion of rights. So I hope that what Maya and I will persuade you of, and I don't think you need persuading in this particular audience, but we'll get to nitty-gritty of strategy and tactics of litigators, but is just about the power of rights as instruments for meaningful and quite profound change. And certainly, I never started out my legal life as a believer in law. I fell into law by accident, but I have become convinced of the power of law and of the power of litigation to effect change. So the subject of this evening's discussion is litigating rights. I'm going to talk about litigating health rights in South Africa under South Africa's 1996 final constitution. And the constitution and the section of the constitution in our Bill of Rights, Chapter 2, Section 27, as Kate has already mentioned, that deals with the right of access to healthcare services, has been pivotal in giving activists power to turn a set of promises on a piece of paper into something tangible in people's lives. But before I get to the actual litigation, I need to give you just a little bit of background about where we started and how it was that health became one of the kind of touchstone issues, if you like, to test the meaning of the Constitution for poor people in South Africa and for disadvantaged people. So the first thing to say is that under apartheid, health was a marker of racial inequality. Spending on health differed according to race, differed substantially according to race. And in apartheid categories, the most was spent on white people, the least was spent on black people, a little bit more was spent on so-called colored people, a little bit more was... So there was a hierarchy of expenditure on health. And obviously, if you have a hierarchy of expenditure on health, you have a hierarchy of health outcomes because there isn't a health system to either prevent or to treat illness. So by the time we got to 1994 and freedom in South Africa, there were stark inequalities in life expectancy, in infant mortality, and in epidemiology and epidemics. Black people, poor people, experienced epidemics of tuberculosis, which had existed for a century, of sexually transmitted diseases because of migrant labor and the hostel system on the gold mines around Johannesburg, many other causes of illness. And then latterly, from the middle of the 1980s, an epidemic of the human immunodeficiency virus, or what we call HIV. And that's the second point I want to make by way of setting a context for litigation, which is that nobody had planned for the HIV epidemic. Not the liberation movements, not the constitution makers, and yet from about 1985, the HIV epidemic began to run very, very rapidly down the fault lines that had been created by apartheid inequalities. Again, migrant labor system, gender inequality, gender violence, the hostel system, etc. So that as we were contemplating freedom in 1994, unbeknownst to the vast majority of people, we by then had an explosive HIV epidemic. Very few people were aware of it at that point because HIV has a long asymptomatic period between infection and the development of symptoms of immune deficiency. But by 1994, we were projecting an epidemic of 5 million infections. In fact, today in South Africa, if you want the shocking statistics, there are 7.5 million people who live with HIV, and I'll come back to that. But I think what the health inequality and then the HIV epidemic meant was that unexpectedly you had this convergence of issues at exactly the same time as the constitution-making process and the immediate bringing into effect of the Constitution, and a convergence of these issues which were fundamental rights in the Constitution, but also fundamental to dignity and fundamental to equality. In fact, I personally had never planned to be an activist in the HIV epidemic. I was involved in the liberation struggle from the time I was at Oxford, but by the early 1990s, when I was introduced to HIV, I realized that the HIV posed a new threat at the very moment when people imagined freedom, a new threat to life and a new threat to equality and to dignity, and it was something that we would have to deal with. So what happened was that when it came to testing the Constitution, although the Constitution contains this provision, everybody has a right of access to healthcare services, including reproductive healthcare, which we often forget that including reproductive healthcare part, and says, and it's a progressively realizable right. Instead of this fight being around the amorphous notion of healthcare, equality of healthcare services, it focused initially on the lightning rod of the HIV epidemic and the needs of people living with HIV for access to treatment. And that, of course, was a life and death issue, because by the middle of the 1990s, or 96, just after we got our freedom, HIV was becoming a manageable and treatable condition in developed countries. But our epidemic was taking off, and an HIV infection in 1997, 1998, or before, almost inevitably meant death. And it also meant inequality, because the only people who could get treatment in 97 or 98 were people who had the benefit of wealth and access to medical insurance. In fact, Kate and my colleague Edwin Cameron, Justice Edwin Cameron, who's just retired, many of you will know from the Constitutional Court, a judge and an activist openly living with HIV. At the point when Edwin started treatment in 1997, it cost 4,000 rand per month for treatment. Today, and I'll come to this, treatment costs about 100 rand per month, and that has a lot to do with successful litigation. But at 4,000 rand per month, there was no possibility of poor people having access. So if you were infected with HIV, for the most part, you died of AIDS. And that was the basis on which we began to litigate the right of access to healthcare services. There isn't time to go into the organizational history or background, except that I want to say that it started with a legal litigation, public interest litigation organization called the Center for Applied Legal Studies, where Edwin Cameron was based and where there had been litigation around political rights in the 1980s. So there was a bridge, if you like. And in the first half decade for the 1990s, much of the litigation around rights focused on rights related to equality, to non-discrimination. We had two very important cases which laid foundations, successful cases. One that Edwin was involved in, the second that I was involved in. The first one established the right to privacy for people in a healthcare setting. It was called the McGeary case. And the second established the right of people living with HIV not to be discriminated at work. Kate, I think, was there for that, known as the Hoffman case. A very important judgment that we won, where the Constitutional Court said, nobody should be condemned to economic death because of HIV infection. But I don't really want to talk about those cases so much as around the cases linked to access to medicines and access to treatment, partly because I think that in the context of this evening's discussion, that's the area where you can provide the most measurable results, if you like, as litigation outcomes. You can talk about the number of lives or deaths prevented as a result of that litigation. It's a long, involved history, and I'm only going to talk about the kind of headline achievements, and again stress that without the Constitution, this would have been impossible. And I have to stress this because still in South Africa today, we have a debate with people who advocate for social justice and on the left about whether the Constitution is a sellout and can play any role in narrowing inequality and improving lives or not. And I think that the proof is in the pudding, as I'll describe. Now, when it comes to access to treatment, there were really two streams to the litigation. And most of this litigation was brought by an organization that I helped to found, and I'm sure we will come to it in the discussion about the link between social movements and litigation, and social movements and lawyers. And it's a critical link, an organization called the Treatment Action Campaign. But I would say that those two streams to litigating health rights were a stream around targeting corporates in relation to the affordability of medicines, and a second stream targeting the state around accessibility. The World Health Organization says when it comes to medicines, you have to have availability, accessibility, affordability, all are necessary. Here we're talking about affordability and accessibility. Skillful litigation by the Treatment Action Campaign in relation to affordability first came into effect to defend a piece of legislation that the South African government had passed to give them powers to issue compulsory licenses, to erode, to some extent, intellectual property law within the framework of the TRIPS agreement of the World Trade Organization. The South African government was busy losing that case, and the Treatment Action Campaign came in and, through an amicus curiae, made it force the pharmaceutical companies eventually to cut their losses and walk out of that case. The fact that the South African government then didn't use the powers that the legislation had gave them is perhaps something we'll come to in the discussion. The other thing I want to say about the novelty of litigation around health rights, which I think the Treatment Action Campaign demonstrated, was its ability to apply other areas of law to constitutional law. So a very important case was brought in 2003 challenging two pharmaceutical companies under competition law, arguing that excessive pricing of medicines was a violation of the right of access to healthcare services and that the state was under an obligation to intervene in the market where there was profiteering from essential medicines. And that case, too, was settled, but it was a critical case because as a result of that case, it became possible to issue voluntary licenses for antiretroviral medicines, which meant that this 4,000 rand a month went very quickly to several hundred rand a month, which meant that medicines became affordable within a few months and affordable to the state to supply through the public healthcare system. So that was that stream. And then the other stream, which those of you who have studied this will know much better, is the cases around affordability that were brought by the Treatment Action Campaign, and the most famous case being what we know as the TAC case, which was a case against the South African government who were refusing to provide a very simple regimen of antiretroviral medicines to pregnant women who had HIV and were at risk of giving birth to children with HIV who would die within the first year in most instances. And we brought that case as the Treatment Action Campaign. The lawyers were the Legal Resources Center. I sometimes forget that because I didn't work for the Legal Resources Center. I always talk about it as if it's our case. But they were very good lawyers, and in particular because they allowed the client to run the show and the lawyers to do what lawyers are very good at doing, which is practice law and do what you ask them to do creatively with law. But that was a very, very difficult, fractured case. I'll mention, because we may come to it later, we brought it in the name of a doctor, a children's rights organization, and the Treatment Action Campaign itself. And it led to a constitutional court order to the South African government to roll out a program to prevent mother-to-child HIV transmission and to make this particular medicine available. Now, if you want to quantify in lives, that's what that case achieved. At the time that we brought that case, 70,000 children were being born with HIV every year. The rate of transmission was approximately 26-30%. Most of those children died. As a result of that case, and because of continued utilization of that case by the Treatment Action Campaign to this day, now there are less than 1,000 children born per year with HIV. And the rate of mother-to-child HIV transmission has gone down to under 2% of all pregnancies. And I think that is a result of successful utilization of litigation by a social movement. So the TAC case broke the resistance. The competition law case made medicines affordable. And the two gave the Treatment Action Campaign impetus and authority to demand treatment as a right for all people living with HIV. And on that wave, we now have 5 million people living with HIV, receiving antiretroviral medicine through the public healthcare system, and therefore able to prevent the development of HIV infection into AIDS. I believe there's a direct causal connection. The causal connection takes many forms. It wasn't just the pure instrumentality of the litigation. It was also the confidence that the litigation gave, the sense of power, the sense of justification. So let me conclude just by saying this. From this litigating health rights, I draw the following conclusions. Firstly, I would make a number of statements about the intrinsic value of rights when it comes to litigation. And I would separate that into an intrinsic value that is both internal and external. Internal, it legitimates rights advocacy. It gives powerless people a sense of power and authority. And I witnessed it with my own eyes. If you call something a right, it has a lot more power. It instills you with a belief in your cause. This is a right, than something that is not a right. And that's often neglected. It doesn't matter what the right standing is in law, strictly speaking. If it's called a right and fought for as a right and believed as a right, then it will put an electricity into a movement. And the second is the power without, what you all know, the power that it allows people to force state to justify, to be transparent, the power of remedy and relief, the power that comes with accountability. The second things I want to just quickly mention is about, when we're talking about litigating rights, is about issues to do with the process of litigating rights. And the point I want to make here is that we often talk about litigating rights as if it's the point where you issue your letter of demand and it stops when you get your judgment. I would argue that the process of litigating rights starts long before that and ends long after the judgment. You know, you start threatening law sometimes without any basis, to be honest with you. But you can do that long before the point, and we were doing it with the Treatment Action Campaign probably for 2 years before we issued the letter of demand in early 2001. And the other misconception is that successfully litigating rights involves getting a successful judgment. Many of the cases in South Africa, not just in relation to health, the victory is often in the settlements, forcing settlements through rights litigation. And then there are just a series of issues that we'll come to in the discussion, what I would call the art of litigating rights. The role of client versus vis-a-vis the lawyer. How you balance individual cases, individual the needs of the individual clients against the public interest, particularly when a settlement is offered to the individual. Knowing when to settle, flexibility in recognizing how the legal terrain will change while you're in the process of litigation, how you use and present evidence in litigation around rights, how you present voices in order to build empathy both inside the court and outside of the court. So let me finish by saying that I think that we can tell the story of litigating health rights in South Africa as a success story with qualifications. We have created, I believe, social justice in relation to HIV. If social justice is defined as equality of access, but HIV has become a sliver in relation to the continued broader injustice in relation to health, the right to health as a whole. And in the last 10 years, we have been trying to use rights and the Constitution to deal with those other injustices. And we've had a much more difficult job of it. And if I hadn't run out of time, I would have told you why I think we're having a difficult job. The new space that we are moving into in terms of politics, economics, shrinking democratic civic space, the primacy of budget issues in responses. I don't have time to go into that, but I do think it presents a whole new set of challenges which all of us need to be thinking very seriously about if we are to retain credibility for human rights and for litigation as a means of unleashing the power that exists within human rights and health rights in this particular instance.
That's fascinating. I think when you started, you described your background and that you were here studying English literature, and that's what taught you to read. I studied French and Italian literature here, and one of the reasons, I think there are a couple of things that are formative for the way in which I use the law now. One was my literature degree. Another was that I then went off and directed theatre, and that was the route where, and it was political, and it was intended to transform the world, change the world, and I think art can. Mine was not doing it in the way I wanted it to, so I left. And in existential crisis, wrote to a couple of charities saying, can I be useful, not expecting anything to come of it. And the place that I ended up was Reprieve. And Reprieve converted me to the law rather than I converted, to law. I had, much like you, been sort of skeptical of the law, and I remain. I think I was right to be. I was angry with it as a small child, which I think is also appropriate, and I've softened with age. But as a tool, it is made to support the structures that exist, and the structures that exist are structures of power. And I was somebody who cared, and I still care deeply about power. It's what attracted me to Reprieve. And so the law was something that was, suggested as an obvious course for me, and I rejected it for years and years and years. And then I got to Reprieve, and I was sitting doing some piece of research when we got this call in about a death penalty case. And Reprieve, Kate mentioned, works on death penalty and then abuses and counter-terrorism issues. Two things that I cared about, somebody who cares about power. Those areas where a state uses the greatest force it can to end the life of one of its citizens or someone else, or abuses its power in the context, really, for us, of the so-called war on terror post 9/11. That abuse of force and power mattered to me a lot. So I arrived at Reprieve, was doing some research on the day that there was an execution scheduled in Arizona. And we got a call in via at the time, the founder of Reprieve at the time, the legal director, who I think probably played a similar role for me as maybe your Marxist guerrilla lawyer played for you. And he got a call from an old Capital, another lawyer from the Deep South who had been doing this death penalty case, said, my guy's scheduled for execution tonight. we've just found out that the drugs they're going to use to kill him have come from somewhere in England. Can you figure out anything about these drugs that we can use? And Clive, who's the founder, called the office and said, look, you know, it's probably hopeless. It's a half-hour research task. Can someone look into this? And I had no idea what I was doing. And I said, absolutely, yeah, I'll look into that. And it was really fascinating to start digging in. I think I'm going to talk about the different things that I think make you successful. And by successful, I mean, you know, your case, you can have an impact in the world in the way that you wish to as somebody who's part of a legal organization. One of the key components is investigation. And I think maybe some lawyers aren't taught to investigate as much as they should be, because facts change everything. And there's a real humility to trying to unearth the facts and digging in. And you might spend hours and hours and hours and hours and hours and, you know, not get anywhere. But those hours are going to be the hours that, certainly in my experience, those are going to be the hours that change the way you can run the case. So in this instance, I dug around. I was trying to understand the pharmaceutical industry for the first time. Figured out a few things about the drugs, that probably they weren't good, maybe they were veterinary, maybe they were unapproved, maybe they were off the back of a truck somewhere. I didn't really know, but I knew enough to say, okay, I think this is bad stuff. Send it across to the lawyer. The lawyer gets me to turn it into an affidavit. That gets filed. And he gets a stay on the basis that the constitutional provision is you have a right to be free from a cruel and unusual execution. So for us, cruel and inhuman, degrading treatment or punishment; for them, cruel and unusual. And he gets a stay. And I cycle home thinking, oh, this is great. And I get back, go to bed, wake up the next morning to the World Service, and they say that Jeffrey Landrigan, after a brief stay of execution, had been executed earlier that morning. So there were a few key things there. One, that he was executed. I have lots of thoughts about the way in which the US, particularly the Supreme Court, interprets that provision of the Eighth Amendment, freedom from cruel and unusual treatment or punishment. I think it's actually about the spectators, us, the public, and the rest of the citizens, and less about the prisoner. And I can come back to that if it's of interest later. So that was one thing. The other thing I'd learned was all about, I mean, at a relatively superficial level, but the pharmaceutical supply chain, which is, in this instance, you had drugs that come from England and had been sent over to a US death row. When you look into it, you discover that there are lots of different links in that chain. That's the first point. Second point, those companies don't want to be associated with executions. They may not care about the death penalty. They may not care about your client, but they don't want to be associated with something that is directly opposed to their PR statements. So those were interesting things. I set those aside. We had discovered that these drugs had been sold from England. This guy was executed over the next, really just days. We tracked the other executions that had taken place using these British drugs and where they had come from. And we, I think probably the next day, the day after Jeffrey Landrigan's execution, wrote to Vince Cable, who was then the business secretary. And it was me writing to the business secretary pretending to be Clive. And so I had to make it really pompous. And he would appreciate my saying that. There was lots of Shakespeare in it. It was a very non-legal style letter, but it was pre-action correspondence. So essentially what we said was, you need to put an export control on this particular product, and you need to do so within 5 minutes, something really unreasonable, because we can be very unreasonable. And again, it's sort of, sometimes you throw out the protocols. Anyway, you need to do this, and if not, we're gonna take you to court. And quite reasonably, Vince Cable said, I'm not sure. And he did take more than it was probably 48 hours we gave him. So we went to court, and I thought for a while, we won that case. And we won that case because in the middle it was an expedited hearing, and sort of a few days in, the government's lawyers came and whispered and said, essentially they changed their position. They said they would impose an export control. This all happened within a matter of weeks of us discovering of Jeffrey Lambskin's execution, in fact. And that, for me, to see it, we didn't win the case in the court, really, because we didn't have to get through to any judge deciding it. We won it because we had our facts right. We had investigated, knew that there wasn't a legitimate supply of sodium thipental, the drug at issue, going from the UK to the US at the time. Therefore, the only drugs being sold to the US at that point, the only sodium thipental being exported to the US at that point, was for the purposes of executions. Our legal case was based on the principle that the British government opposes the death penalty, our law does not allow for it, and therefore in some way assisting or facilitating the death penalty in another jurisdiction, even though it's through what you have failed to do rather than what you are actively doing, is unlawful. That was our legal argument. We investigated, got the facts, but we also made a lot of noise about the case in the Court of Public Opinion, one of the really important court fora that you'll have to work in, I think, if you're going to be successful in terms of litigating rights and impact litigation. And we were also pretty active politically. And that gets you to, so they changed their mind, they put an export control in place on sodium thipental, we then get that same export control in place across Europe. I then work, I'll talk briefly about the work that we did then, because I think it gives you an example of this theory that we have. You can work in the court of law, but if you're dealing with a system that is structured to support those with power, and your job is to try to place yourself between the people with the power and the people without, or to provide additional power to those powerless, that structurally have been deprived of that power or being abused, you are going to have to find other court fora to occupy at the same time. Or you're going to have to be really creative with the law, which is also something that I think you'll see in these organisations. So for me, over the years, I've stripped it down to, I think there are sort of 4 main courts, but there may be more and you should throw them out. In fact, there's probably 5 that I could name. The main ones, the traditional courts, which are untraditional, are Court of Law, fine. Court of Public Opinion, the press, the media, you can't always do it, but when you can do it, it will boost a certain line of argumentation if you're strategic about it. You have a political courtroom, the halls of power. Then you have a corporate courtroom, which is where I'll go next. I think the 5th one would be a sort of artistic one, perhaps, that maybe we are not doing. And you had Wolfgang here recently. I know he thinks about this a lot. I think maybe as lawyers and legal organisations and third sector organisations, we could be exploiting that courtroom a little in a more sophisticated way. But I, through that first JR, experienced the way in which the other court fora that we were using won us the case in the court of law. And it wasn't actually, I don't want to say we wouldn't have won, but I think it's possible that the law wasn't on our side at that point. But we got what we needed at that point. And then, of course, all these states couldn't get hold of that one drug. They moved to other drugs. And I don't want to take too long over this, but I think it's worth talking a little bit about the work that we then did on the issue of the drugs used in executions, because it could look very oblique. This isn't the key. If you're talking about the death penalty, one might think that you would be trying to litigate issues of innocence. And if you have an innocent client, absolutely you are doing that. But as an organisation that's trying to make a change in an area where a lot of progress has been made, but it's also extremely difficult to win those sorts of cases, I think sometimes coming at issues from this oblique angle, or according to the Supreme Court Justice, who, may he rest in peace, Scalia, guerrilla lawfare, guerrilla attack on the death penalty, sometimes you do need to be looking at things from these different angles. So, oddly, I started working with pharmaceutical companies to try to change the way in which the US carried out executions. And the theory of this was the US uses the lethal injection because it's a palatable, it looks clinical, it seems palatable, it is the modern face of the death penalty. And of course, it's anything but that. So if you move states away from the lethal injection, you see approval ratings for the death penalty per se just drop dramatically, but you also see fewer executions because it's the practical mechanics, it's sand in the machine. And what I discovered on that first evening of researching this was these companies don't want anything to do with the death penalty. These medicines weren't made for this purpose. And they go through lots of different jurisdictions before they end up in the US on these death rows. So what we did at that point was worked with the first company. I had this conviction that these companies could control where their medicines go. They can. In order to convince the first company, I had to design the distribution system for them. That required me, as somebody who also is not a real lawyer, or you are a real lawyer, I'm not a real lawyer, to design these distribution systems. It wasn't just contractual arrangements, it was understanding the way in which that industry worked in order to be able to work out what do you need to do to ensure that a company can protect its medicines and ensure they go to the right place and not the wrong place. It was highly technical, figured it out, ended up, one other snapshot, along the way, did lots of press in Denmark, the company was Danish, including, on one occasion, bringing a lizard to a press conference, which I put on the table, a live lizard. Everybody you know will be useful at some point too. I had a live lizard there because my theatre friends in Denmark, I had a prop person who had got me props for lots of the shows I'd done. She went and got me a live lizard, placed it on the table. This got the attention of various people. But the real key to that case was not the lizard, although it did get under the skin of one of the guys at Lundbeck, but designing the system that was going to work. And I ended up in a meeting with the CEO of this company who, when I described the system, his PR guy, who was the one who got really upset about the lizard, said, yeah, but we're stuck between a rock and a hard place. We have all these patients, just a small number of prisoners, and can't deprive all those patients, which sounds very rational, but it was this false dichotomy that a lot of companies had used over the years. And the CEO put his hand across and said, well, wait, why can't we do what she's saying? Why can't we implement this system? Because I had designed it and it was clear that it would work. And if you actually were invested, there were two things that happened. One, I'd made it matter. And if you can, and people often ask about working with corporations, if you can, in the Venn diagram of your interests and theirs, they do hold a lot of power. And if you are trying to help people without power, you want to bring as many powerful people to the table as you can in order to advocate for the people that you're trying to assist. Sometimes they don't care. Sometimes you can bring them to care, and if there's a crossover in the Venn diagram of their interest and yours, that's where you've got some real potential. So we managed to convince this company to put the controls in place, and over the last few years, every other company has done so as well. One of the things I mentioned, the different court fora, I think as lawyers, and particularly if you work in a legal organization and you're not directly representing individuals, you get to play in lots of different jurisdictions as well as different court fora. So when one of the companies I was working with didn't immediately want to do what I thought was the right thing to do for their business and also our interests, they were really pushing up against us and we were having a bit of a fight. And then they inverted, they did tax inversion, and they moved over to the Netherlands. And suddenly they were in this other jurisdiction where we could file an OECD complaint and do various other things because they had exposed themselves to a whole other legal system. So a lot of what Reprieve does is tries to leverage these different international actors using the law. And the last thing I will talk about, because there isn't a lot of time and I want to make sure there is time for conversations, is just on that same theme. I think it's incredibly creative. It's a really fun, creative endeavor to use the law in this way, where you're looking at the world and you're looking at the different legal systems and basically the principles, human rights principles, if those are the rights that you're working on, and figuring out where you might have some leverage, looking at the connections between different governments and different supply chains or whatever other links you can find. But equally, don't just look at the traditional legal frameworks. It's not, the Human Rights Act in Britain, British courts, and indeed the government, if you're fighting the state, they know those arguments. They are really well armored against them. And the national security arguments, they're really hard challenges to bring because the law is against us. But if, as somebody who works in an organization, you can be thinking about the contract law, and that can stay in execution because some company actually intervenes and says, my contract's been broken here, and then you end up not having somebody executed in Nevada, which happened last year. That's amazing. Or we use the Data Protection Act, which sounds like a really dry piece of legislation, but we've managed to get exculpatory evidence about one of our guys on death row, who was on death row actually. He was put there with the assistance of the Brits, and it was in Kenya. And through the litigation, and it was both, there was a judicial review, which we didn't get to the end of, but we did get disclosure, which was very, very helpful. But I think the law is a tool for forcing governments to be a bit more transparent. It's incredibly helpful. And then you have to be creative with what you get. And this DPA case, in 2 instances of British complicity in the death penalty, in 2 jurisdictions, Thailand and Kenya, we were able to get information that contributed to us being able to advocate for those individuals, and in one case, the death sentence was overturned. The other one is pending an appeal. So I think that's my message to lawyers in general is that, yes, the law is very useful, and if you want to do individual cases, we need lawyers who are working on individual cases, and I have so much respect for the people who are doing that. But if your interest is in working in a way within an organization and trying to affect change that's structural, systemic, you may want to consider perhaps pulling away from quite a narrow view of what the law is and trying to play in these different courtrooms that have opened up to us, and it's really fun.
Mark spoke more about clients, but Maya, you didn't speak that much about clients, and I wondered whether one thinks about who makes decisions about legal strategy in circumstances where you have a client, whether an individual or an organization or social movements, and how you manage that decision around strategy and the relationship with clients, and also how one manages a situation where there may be a conflict of interest or between an outcome or a strategy an individual client or organization wants and the one that you think is appropriate for the goal of the litigation.
Yeah.
Do you want to start?
Sure. Well, I'll start with the first piece, just on the client. That's right. In the particular project that I talked about, I didn't reference the individuals, although as a casework-led organisation, of course, at the heart of it, the first case was Jeffrey Landrigan's case. The second case, the judicial review was brought on behalf of Ed Zagorski. So there are people at the heart of it. With the lethal injection work, it's a strategy that is quite complementary to the work that the individual lawyers are doing to try to save the life in the criminal proceedings, exactly. So I think it's unusual for there to be a conflict in that circumstance because the objectives are the same and we occupy sometimes slightly different terrains. The only area where it does get complicated, and I think it's very interesting, is around strategies on method. So if you think that the end of the death penalty will come about because states will move away from lethal injection, and you are in a position where your client gets to pick which method of execution they, not even gets to, is obliged to pick a method of execution, there can be conflicts. And then, of course, it has to come from the individual. But if you are working as an organisation, we have a set of cases right now in Syria where I work with a number of individuals. You will litigate on behalf of the person where their interests and your interests align. And what you may not do is throw a lot of your resource behind a case if you don't think it's going to have an impact for the, if you don't think it's strategic. So I think there are usually ways to navigate a potential conflict, and I think it is about being really honest in the conversation and the way in which you pick cases, incredibly strategic on the cases you pick. But I also think sometimes that conflict can be overstated, and often it's possible to find a way, if you're being very creative, to ensure that anything you do is serving both the broader interest and the individuals. But perhaps, it sounds quite general, I think.
No, I agree. I think it's hard to make hard and fast rules. it will differ from case to case. And so really what you need to do is to try to work out what's a set of guiding principles and then check off those guiding principles as to what to do in a particular situation. And I think it'll differ as to whether a client is an individual or whether it's a powerful social movement. I've faced this on quite a number of times. And taking the individuals, and there's always lessons to this, is ultimately if a client's interests, individual interests, have to be paramount. So I mentioned the South African Airways case. Before it got to the Constitutional Court, the case actually started with a case that was run by the AIDS Law Project, a person called A, and we built a beautiful case. We got a lot of publicity. We began to shape public opinion. We had all the right facts. And then South African Airways came along and offered 100,000 rand. And for this person, 100,000 rand was manna from heaven. We had no choice, ultimately, but to go with the client's wishes to settle that case. And for a person living with HIV as well, was also the fear of the spotlight, the issues of confidentiality, a whole bunch of stresses. But if you're in it for the long haul, what happened with the South African Airways case was, well, we were later able to bring in all of that evidence that we got in another case of exactly the same facts. So we won that case eventually. One of the lessons we've drawn from that subsequently, and we sometimes forget to apply it, is try to have if you're working for an individual, try to have a organizational client as well. So that if the state tries to settle, or whoever tries to settle with the individual, the case can be carried forward by an NGO or by a social movement. Then the other thing that I would say, just in response to that, though, is that it is a tricky relationship. And I joked about the treatment action campaign. In this case, I would say I was the treatment action campaign, and the legal resources center was the lawyers. I think, first of all, that the lawyers have a responsibility to empower the client organization in the law. So to try to narrow that information asymmetry so that there can actually be a real discussion about at critical moments of legal strategy. And within the TAC, we always not just made sure that the team that worked with the lawyers understood the law, but we also made sure that the members of the treatment action campaign understood the law. And people in branches in the most poorest parts of South Africa could talk about the medicines and the virology of the medicines and how they were patented and secondary patents and could often say to us, no, people don't go in that particular direction. But it's a balance, because what I find with people who are trained as lawyers is there's often a conservatism. Even amongst the most progressive of trained lawyers, there's a point at which a lawyer will tell you there's a wall there and you can't go past that wall. And we will often say, no, you can go past that wall. Actually, believe us, you can go past that wall. But we too have to accept that you bring lawyers on board for a reason, which is that they have knowledge, they have expertise, they know what they're talking about for the most part. So it's a dialogue. It's a continual dialogue to work out what is the best way forward, where both have to be prepared at different points to defer to the other.
Yeah.
I would add one more person into the dialogue. I agree that it absolutely. Something we've been doing increasingly is working with a clinical psychologist. And we've brought her into some of the cases where it started where there were some victims who wanted to participate in both the civil actions and then the criminal actions, but they had been victims in the case. So we needed to ensure that their interests feel ethically secure, that their interests were being sort of respected, and that they weren't being dragged along. They wanted to work with us, but we are not clinical psychologists ourselves, and this was a very vulnerable person. And what I've seen in working with this particular individual who's absolutely brilliant and really thinks about justice and what justice means to individuals, and obviously we have to think about it too. You talked about rights, and that was really fascinating. There is a different, going through a process and being treated with respect and being given the information is such a big part of how people feel about the outcome. It's not necessarily that there was a conflict between one strategic line of thinking and another, or sometimes it's simple. There's a damages claim, and somebody settles or they don't. But even just small decisions where you lose a client, it can be because they feel like they've been treated badly in the process. And lawyers are, one, not massively creative, two, often not the best equipped to work humanly with the clients. And we do work with some of the most vulnerable people, many of whom have been tortured, many of whom remain in conditions which could constitute torture, ongoing torture. So there's another person in the dialogue, I think, or another potential entity who can help us navigate some of these tricky questions of what justice feels like for a client versus broader issues.
Can I just, I'm sorry to do this,
No,
but I
go
because
ahead.
I think it's an important point, is that litigation around rights can build citizens. I don't use citizens in a narrow nationalistic sense, and I've seen it on numerous occasions, and that's so important for society and for social fabric. And now I often give this example because I like to call up her memory. In the TAC case, there was a woman called Sarah Tlatlele who lived with HIV, and she had a horrible story, terrible, tragic story. Because of stigma, she had to go to a faraway hospital to get a nevirapine tablet because she didn't want to be seen close to where she lived. And then she went into labor prematurely and forgot her tablet and was taken to a local hospital. And so she knew everything about how this medicine reduced the risk of transmitting to the baby, but she couldn't tell the people at the hospital, and they weren't providing the medicines at that point. And that was the story of Sarah and how her baby was born with HIV. But I went to meet Sarah. And the first time I met Sarah, and this transition I'm about to describe took place in probably a year, I met her in a place called Sharpeville, and I went into her little house and asked to see Sarah. And there was Sarah sitting in a corner of the room on the floor, eating out of a saucepan, because the people she was living with wouldn't let her use the cutlery and so on because of stigma and fear of HIV, sobbing uncontrollably, this completely broken person. And we built a relationship with Sarah through the litigation, through the campaign. And within a year, I remember after the court case, before the Constitutional Court, seeing this person who one day stood outside of the Pretoria High Court with her baby in her HIV-positive T-shirt, talking to the media and saying who she was, what she was, why she was involved in this litigation. And that happens. And it happens in the situations that Maya's talking about. It happens in the situation that we described. And I think it's an enormous plus to litigating rights.
And you could have lost her. And if you had lost her, if she had decided she didn't want to pursue the case because it was too traumatic, people might then have said it was, it was a sort of strategic conflict. Sometimes these things that are just very human are at the heart of something that we create, we decide is political or legal strategic conflict. Anyway.
Well, thank you both for really very engaged responses to all those questions and a very interesting evening. Would you join me in thanking our two visitors?
Thank you. Thanks for having me.